Good afternoon to everybody. I'm pleased to introduce this today's conference on antitrust and regulation for online platforms. As some of you already know, this event, this conference, constitutes a new initiative belonging to a wider project. As since 2015, our department is regularly organizing events, special lectures, international conferences devoted to competition law and policy. We had in the recent years, we have also the pleasure of having a special partner in these events, as we have the Italian Competition Authority, which collaborates for us in these kind of initiatives. I will say just a very few words about today's conference. As we all know, digitization is in the recent year is at the heart of the attention at legal, social, and political level. Well, despite the general acknowledgement of the benefits that digital economy and innovation is bringing to our society, there are increasing concern and there is an increasing anxiety about its impact and about the concentration mainly of power by a few large companies. Digital platforms, data, digital technologies, they all they are at the heart of the academic and policy discussion and pose several challenges to competition law. Enforcers and scholars are working in order to improve also our understanding of digital markets and of their peculiar features. The first main question that this conference is aimed at addressing relates first of all the dichotomy between antitrust and regulation, and which of them may constitute the most appropriate and the most appropriate means to deal with such policy challenges. And considerable efforts have been made in this direction. We can say that also very valuable insights have come from the work that has been done also by many experts. This year we had at least 3 very important reports that have been released and that contribute in this matter. I'm referring, for instance, to the long-awaited report commissioned by the Commissioner Vestager, released in April 2019, Competition Policy for the Digital Era. And we had last September a report released by a group of the University of Chicago, the Stigler Committee on Digital Platform. Well before this, we had the formal report, Unlocking Digital Competition, the report of the UK Digital Competition Expert Panel, which has been released in March. And which all these reports deal with the topic of the data, of the market features, of the merger control, and with the relationship with regulation. In particular, with regard to the formal report, a co-author of this report is Philip Marson. We have the honor of having him today, so we will discuss with him also the insights from this report, I suppose. Among the various measures that have been the policy recommendation that this report also consider, there is the proposal for the establishment of a digital market unit. So, of course, this is, of course, worth of mention. Moreover, again, with regard to the relationship between regulation and competition, a direct example of regulatory intervention in this field comes from the European experience and the recent adoption of the regulation on fairness and transparency in online platform-to-business relationship, which has introduced a framework for minimum transparency transparency and redress rights. Such intervention is accompanied by the Observatory on the Online Platform Economy. Inge Greif, who is part of this group, joins also the expert group supporting the Commission in monitoring the evolution of the online platform economy. Inge will explore the topic of differentiated treatment in platform-to-business relationship, which is a key focus in current competition investigation at European and national level. A second question that has been treated also in the reports that I've mentioned is whether the existing antitrust toolkit and rules are sufficient to deal with cases involving technology companies such as online platforms, or rather new rules should be elaborated. We will discuss, for instance, with Thibaut Schrepel, which is late due to a strike in France, but he will join us in an hour, we hope. We will discuss with Thibaut whether, for instance, new types of practices should be recognized, such as that of predatory innovation practices in high-tech markets, and also the risk for competitions that may derive from such kind of practices combined with blockchain. Coming to new proposals, in Germany, in the draft bill of the German Competition Act published last October, some important new provisions for intermediaries, access to data, and companies with paramount significance across markets have been established. We were supposed to comment these measures with Rupert Poston, who unfortunately is sick at home. However, we will have a video from him, and also Rupert will join us for the Q&A at the end of the presentation, so for the discussion. Not only legislative measures, also cases and investigation at national level constitute crucial elements in this debate. The recent outcome of the well-known Facebook investigation by the Bundeskartellamt, for instance, whose decision has been quashed by the higher regional court of Düsseldorf, tells us how such issues are very far from being unanimously solved. As a matter of fact, we have already experienced inconsistencies among the approaches adopted by national competition authorities in other cases, for instance. One main example is the investigation regarding Booking.com, where we had different stances taken from the Italian, the Swedish, and the French competition authority on the one side, and by the German authority on the other side. Moreover, in this case, which is particularly informative of the situation of the digital markets, ad hoc regulatory measures by governments have been also adopted, in contrast also with the outcomes of the competition authorities' investigation. So, of course, it is this constitutes a case worth of study for the implication for the policy approaches to the digital markets. And Andrea Mantovani will show us the results of the empirical study that he has conducted together with some colleagues on the effective outcomes of the measures adopted in these investigations. In this context, also the Italian experience, of course, is particularly meaningful. As a matter of fact, the Italian Competition Authority has been particularly active in this field. Just to mention the very recent cases, 1 year ago, the Italian Competition Authority sanctioned Facebook for unfair commercial practices for using its subscribers' data for commercial purposes. Last April, a new investigation against Amazon has been started for abuse of dominant position in e-commerce and logistics services, and namely for self-preferencing practices. And lastly, in May, an investigation against Google for suspected abuse of dominant position by refusal of including the app of Enel, the energy provider, in Android Auto. Andrea Pezzoli will illustrate us the approach adopted by the Italian Competition Authority in this field. To conclude, I would like, of course, thank the speakers that are here today for having accepted our invitation, and of course, all the participants to this conference. It is my pleasure to leave the floor to Philip. Thank you. So, Philip Martzen, Professor of Competition Law and Economics at the College of Europe and Deputy Chair, Enforcement Decision-Making Committee of the Bank of England, will deliver his presentation on 2020 and beyond.